Thank you, Honorable Speaker. We are engaged in nation building. We are here to prepare the architectural sketch on which the foundation of the nation must be erected. Honorable Speaker, Section 101 of the Constitution, subsection 2, states that no bill except a particular kind of bill shall be introduced into the National Assembly unless it is accompanied by an explanatory memorandum setting out in detail the policy and principles of the bill, the defects which it is intended to remedy, and the necessity for its introduction. Honorable Speaker, our Standing Order 64 states that every bill shall be accompanied by a memorandum signed by the person in charge of the bill, containing a statement of the objects and reasons of the bill, including the nature of the issue the bill is intended to address, the main options considered, the consultative processes undertaken, and the rationale for the approach taken in the bill. A statement of delegation of legislative powers and limitation of fundamental rights and freedoms, if any, an indication whether it concerns regional government, and a statement of its financial implications, and if the expenditure of public monies will be involved, should the bill be enacted, an estimate, where possible, of such expenditure. No bill shall be introduced unless accompanied by the memorandum referred to in paragraph 1. Honorable Speaker, a bill is before us. The Constitution of the Republic of the Gambia 2020 Promulgation Bill. It has an explanatory memorandum stating the objects and reasons that this bill seeks to promote for the promulgation of the Constitution of the Republic of the Gambia 2020 and to repeal the Constitution of the Republic of the Gambia 1997. Yes, the mover of the bill, the motion, the person in charge of the bill could have extended the objects and reasons. But do we need that? This bill is a byproduct of our own actions. We passed the bill that gave rise to the Constitutional Review Commission Act 2017. We are very clear what we wanted the commission we made to come into being by the act that is our handiwork. Honorable Speaker, Section 6 states very clear the functions of the commission are to draft a new constitution and prepare a report in relation to the constitution. Here is the report. And you look at their report, they've explained all the elements that are required by Standing Order 64. And what is amazing, Honorable Speaker, is that the report gives us references of the consultative process, the literature review that they had undertaken in order to come up with the draft. And part of the references that I can see, 32 Malawi Citizenship Act, 33 Malawi Constitution, 34 Kenya Constitution. Plagiarism is to quote without making reference and ensuring that you give authority to where authority is due. This parliament is not an ordinary institution. Outsiders cannot come and stand here and speak. Before we make allegations, we must make sure that they are situated in truth. Otherwise, we're undermining the integrity of this National Assembly. Honorable Speaker, we have said we charge the Commission with these responsibilities in carrying out its functions under subsection 1 of the Constitution, seek public opinion and take into account such proposals as it considers appropriate. Considers appropriate, that has content, form, and context. You cannot consider any matter without checking the context. What are you able to do? And you have to make reference to time. How much time do you have to do it? All this matters. So if we are to gauge, we must gauge based on those standards. Honorable Speaker, it says that they must review the 1997 Constitution. So if you find provisions of the 1997 Constitution embedded in the draft, that is what is supposed to happen. If they are convinced that those provisions are authentic and should be there, that's the duty you've given them. That they must adhere to the national values and ethics. They must safeguard and promote the following matters: the existence of the Gambia as a sovereign independent state, the supremacy of the sovereignty of the Republic. What is there in the first chapter? It's talking about what? The sovereignty of the Republic and the sovereignty of the people. That's what we have asked them to do. That's the principle. Honorable Speaker, it says that they must ensure that the existence of the Gambia as a sovereign independent state must be asserted. The Gambia's republican system of governance, including its democratic values and respect for and promotion of the rule of law and fundamental rights and freedoms. Honorable Speaker, if you look at the whole draft, you will see the provisions. Clause 11, national values and principles. Clause 85, guiding principles of executive authority. 134, principles of parliamentary governance. 238, principle of decentralization. And then 203, principles of decentralization. 238, principles of public finance. 171, principles of justice. 283, principle of national security. So everything that is there embedded in this Constitution, in the draft, lie on a foundation of principles. Principles can be mere ideas, but it can also be concrete law. And that's what they have sought to do, to provide the principles and then make the law, so that you know why the law is there, for us to be able to gauge whether they have actually served us in the right way. Honorable Speaker, it mentions the separation of powers, national unity, cohesion, and peace, the importance of ensuring periodic democratic elections based on universal adult suffrage, including the introduction of term limits for serving in the office of president. We instructed them. This is an instruction. The Gambia continued existence as a secular state in which all faiths are treated equally and encouraged to foster national cohesion and unity. We are all sovereign. We own the Gambia. We are all voters. We belong to different religions. He said that all faiths must be respected. Imagine the debate that this generated. People talking about everything in the sky except what a constitution is. And what the constitution is a mundane instrument. You look at the 1965 constitution. What is there? That executive power lies in Her Majesty. Is that from above? In which religious book would you find that? That's a mundane instrument. We move away from that up to the 1970 Constitution, giving you the authority to determine your manner of existence. To the 1997, and now we're thinking of moving forward. It moves qualitatively from one stage to another. That's what development is all about. So we are here today about development, Honorable Speaker. That's the object. The object is to move forward. And we must ask ourselves the question, do we have the instrument that can help us to move to the next stage? We'll continue to move to higher and higher stages. We will never get there because development will always be higher and higher stages. So the context must determine content and must determine form. The context in which we are in, Honorable Speaker, is that we inherited a 1997 Constitution. We've been using the Constitution. You can see how much it has served us to be able to vet appointments up to the Office of Ombudsman. We rejected. You can see then the powers we have under the Constitution. And because of our ignorance, we could not even utilize the Constitution, because some people continue to say a soldier's Constitution. But then we can see the powers we have to the point of determining our own income, where the executive rejected it. But we relied on the Constitution. By force, they must do it. And the Accountant General had to do it because of what was read in the Constitution. We could not master our own domain and to be the architects of our own destiny by virtue of ignorance. And that ignorance must not continue to be replicated by not understanding what is before us, Honorable Speaker. The objects are clear. The reasons are clear. That we assign them to do all these things, Honorable Speaker. And if you go, the thread of this Constitution is all the 20 chapters is precisely based on what we assign them to do. So are we now going to transform ourselves into drafters? Then why did we assign them the responsibility? Why didn't we do it ourselves? Because that was said in the first place, Honorable Speaker, that they are asking us to promulgate on the basis of Section 226 of the Constitution. But, Honorable Speaker, Section 226 has two elements. And those two elements cannot be the same. One element are the provisions in the 1997 Constitution that can be amended through and by this Parliament without having to send anything to anybody for a referendum. And that is very clearly stipulated under Section 226, 1 up to 3. So it is important, Honorable Speaker, that we look into that. Honorable Speaker, it says And it has been read, but I will refer to it to emphasize, for the sake of emphasis, that subject to subsection 4, a bill for an act of the National Assembly, unless this section, under this section, shall not be passed by the National Assembly or presented to the President for assent, unless before the first reading of the bill in the National Assembly, the bill is published in at least 2 issues of the Gazette, the latest publication being not later than 3 months after the first, and the bill is introduced into the National Assembly not earlier than 10 days after the latest publication. So it gives a limit of 3 months, 10 days to ensure that it is introduced before us. When it is introduced before us, it says the bill is supported on the second and third reading by the votes of not less than 3/4 of all the members of the National Assembly. What happens after that? It says under subsection 3, if the President fails to assent within 30 days to a bill passed by the National Assembly in accordance with subsection 2, the bill shall be referred to the Speaker, who shall refer it to the Independent Electoral Commission. The Independent Electoral Commission shall cause a referendum to be held on the bill in accordance with subsection 4, and if the bill is supported on such a referendum by the majority of voters provided for in that subsection, it shall again be presented to the President for his or her action. A bill to any act, well, that is the first element. Honorable Speaker, it means this National Assembly does not have monopoly like we have with other laws, where we pass and the President must assent or return it to us, and when we return, by force he must assent. But when it comes to the Constitution, when he rejects, we must go to a referendum. So there's nothing we can do here, change anything, that we believe whatever we change is something that must go to the President. And if he rejects it, we must go to a referendum. Now, what is the second element? The second element deals with subsection 4 to 7. It says that a bill for an act of the National Assembly altering any provisions referred to in subsection 7, and subsection 7, those are the entrenched clauses. So when you have the entrenched clauses, shall not be passed. We are not supposed to even pass it. Shall not be passed by the National Assembly or presented to the President for assent. So it's not even passed, it's not presented to the President. So what happens to it? It says that the bill, a bill of that nature, unless the bill is published and introduced in the manner required by paragraph B, paragraph A of subsection 2, which we have passed, the bill is supported on the second and third reading by the votes of not less than 3/4 of all the members of the National Assembly. Supported, not passed, supported. Now, once it is supported, the bill has to be referred to the Speaker, has been referred by the Speaker to the Independent Electoral Commission, and the Commission has within 6 months, bear that in mind, has within 6 months, so you see how we are getting tight, has within 6 months of the reference held a referendum on the bill. So within 6 months, the IEC must hold a referendum on the bill to deal with entrenched clauses. Honorable Speaker, it is important to see that the IEC is scheduling a referendum in June 2021, according to its calendar. So you see how things will have to change. And it is this National Assembly that must be the game changer. This is our responsibility. That's why we're an oversight institution. All these people are coming to us with hope that a way must be found to be able to address the context that we find ourselves. So, Honorable Speaker, it is emphasizing then that how will it pass? At least 50% of the persons entitled to vote in the referendum have taken part in the referendum, and the bill is supported in the referendum by at least 75% of those who voted. Now, the critical situation we have here is that the draft constitution has both provisions which touch on the entrance clauses and provisions which we can change in this national assembly. That's why when we started the debate, it was felt that, well, going and changing what we could and going for a referendum to the others maybe would have been the best judgment. But that is history. Now we have taken this route. How do we come at a level where we see light at the end of the tunnel? That is really what we must discuss. That's the essence of what we are doing here. We are looking at the merits of the law to assist us to achieve the objects and reasons that are put before us. Promulgation of the Constitution and repeal of the 1997 Constitution. How are we going to achieve that? So, Honorable Speaker, looking at the situation, you will see that it becomes very significant to look at Clause 9 of Section 226. It says in this section, reference to this Constitution includes reference to any law that amends or replaces any of the provisions of this Constitution. Reference to the alteration of the Constitution includes references to the amendments, modification, or reenactment with or without amendment or modification of the Constitution or of any provision of this for the time being contained in this Constitution, the suspension or repeal or the making of different provision in lieu thereof, and the addition of new provisions of this Constitution. Now, if you look at the situation, you will see that it is talking about reenactment. It is talking about modification. It is talking about amendment of different sorts, with or without amendment. So elements are sieved out as to what alteration means. Now, how do we promulgate? Is there anything in Section 226 that shows how we are going to promulgate a constitution with both entrenched and non-entrenched clauses? Well, that is the issue here. So it is important for us to look at this critically and for the mover to look at this critically so that we know exactly where we are going. Honorable Speaker, if you look at the 1997 Constitution, you will see in the transitional provisions Section 232, page 122, is where you find the transitional provision, but it has schedules. And the second schedule, 123, tells us at paragraph 2, election of the first president. Notwithstanding any other provision of this Constitution, the person duly elected President of the Gambia in accordance with the Elections Decree 1996 shall be the President of the Second Republic of the Gambia and shall assume office as President on the date he or she is sworn in. The first President shall hold the office of President in accordance with the provision of this Constitution. This Constitution shall come into effect upon the swearing in of the first President. There was no assembly when the President was elected. The President was sworn in, and that was deemed to be wrong. And the Chief Justice acknowledged that when that was criticized, because he saw that the swearing of the President should have brought in the Constitution into force, and how can a Constitution come into force without a National Assembly, without the bodies in the Constitution? So they had to wait up to the National Assembly elections before the President was sworn in again, so that the Constitution will come into force. Then they rushed the Constitution before that to the National Assembly, so that the National Assembly will promulgate it. And this Honorable Woolly West refused at that time to engage in that exercise until the President was sworn in, so that the Constitution will come into force. Now, how will the draft Constitution come into force? We will not look at the details, but I am sure they know the details. And if you look at the details, we're saying after a referendum. Now, we are told in 1997 Constitution, a referendum within 6 months. Is the IEC ready for a referendum? It's envisaging 2021 June. So in that regard, could we resort to something else to try to remedy the situation? Look at Section 102. Section 102 of the Constitution, Honorable Speaker, is actually telling us that Section 102E, that any bill introduced in the National Assembly may include in the bill a proposal for a referendum on an issue of national concern defined in the bill. Of course, promulgation of a new constitution is a matter of national concern. The mover should look into this possibility and see whether we could not add 226 with 102 together. Somehow move towards a referendum where it will be introduced in the bill that we move to a referendum. And members, it is clear that if we touch even a scratch in this, and we believe we have power to do so, we must send it to the President. And if he rejects it, we'll go to a referendum. And some of those who are trying to defend, read the mind of the executive. I don't know how we've become psychologists as National Assembly members. What I see before me, Honorable Speaker, is the Honorable Attorney General and Minister of Justice. That's what I see here. Who belongs to a cabinet, who had the responsibility. The President who presides over that cabinet has the responsibility under Section 21 of the Act to receive this document. It says the Commission shall, upon the completion of its work, submit a constitution and a report thereon to the President. That has been done. What should happen after that? Publication by the Commission. The Commission shall, upon the submission of the draft Constitution and report to the President, publish the Constitution and the report. That has been done. And not only that, the Constitution and the report may, in addition to being published in the Gazette, be published in such other manner as the Commission considers fit. That has been done. And it is the Honorable Attorney General who laid this motion and this bill before us. So the issue is not about the executive, it's us. The executive did not touch it. Yes, the principles are there. For example, Honorable Speaker, the principle of the secularity of the Gambia is not written there directly. But if you look at 88, that was the problem we had in the past, where a president would just get up and say, I've declared Gambia as this state. 88 is restricting that. Yes, maybe it should be entrenched. I've not seen that it is entrenched, but it should be entrenched. But you look at 153, we cannot pass any law that declares a state as a particular state of this form. So that is clear. Now, the contradiction in terms of object and reason, Honorable Speaker, some are saying that is not adequate. Put secular there, and don't put Sharia there, because that will show that you are aligning with a particular religion. Let us look at these principles very clearly. What is best is to have put secular. But within the context of the commission, they say, well, this is what we can put. That's the job we assign them. That's what they can do. That's the context and the content. That's what they can do. But to those who may say, I will vote against this constitution because secular is not there, well, they must rethink. Those who will say, I will not vote because Sharia is there, they must rethink. Because the fundamental rights and freedom gives power not to be discriminated. It's an equality principle. Whilst a religion may have its peculiarities to those who believe in it. So if the religion says this is how you should share, based on the religion, because the obligations are different, and it is not put in the constitution that the laws of that religion is respected for those people who believe in that religion, it means that you can rely on the state, the constitution, on the discrimination clause to claim for a right that goes against the very principle of that religion. Then why don't you just abandon the religion and go and marry have a state marriage? Or convert to another religion? Why should you worry to belong to a religion that you don't have faith in? Nobody stops you from doing that. And those are the safeguards that we must put into consideration to be able to move forward, to respect the group rights, to explain things very clearly so that we understand that we want a united Gambia and we want to move forward. Yes, there are inadequacies. A citizen is a citizen, for example. Why should you say that somebody who have acquired the citizenship of another country cannot stand here and be a president in the Gambia? Why? Because the whole purpose of expanding your territory is for your people to go and become somebody else as long as they are loyal to the state. You could say, for example, that yes, you can stand for elections, but then once you are elected, you must renounce the citizenship of another country. So it's how you frame it. You can say that once elected president, you cannot continue to maintain the citizenship of another country. But you cannot say somebody, I'm just saying, these are general things that we can continue to fight for, eventually for amendments. But should we say no to this because of those things that we know ultimately we'll have to fight for in order to achieve? Well, that is the question before us. That's why we're talking about context, determining content. Even those people who are part of the commission may have certain beliefs, ideologies, thinking, strong ones. And when they look at the provision, they may really want to rebel against themselves. But what can they do? Because maybe doing certain things will make others reject. And therefore, will you succeed? So therefore, context will therefore determine content, and that's what this assembly should bear in mind. That each of us, as the member for Woolly has said, in terms of citizenship, but some will go against that. So if it's put there, what would they do? So essentially, they throw it back to us, and we're coming. Know that some people will come with a private member's bill if the state does not come, and the state must get that responsibility. Reject it, fine, and they will know who had rejected this. And then when you want to leave the country and for your brother, sister, to be a citizen of another country, we'll tell them to reject it. Then we see what type of world we'll have. We are ready for that battle, Honorable Speaker, on the basis of principles. But principles must be guided by context. What is achievable at this time is what we should seek to achieve. And Honorable Speaker, I will conclude on that note that if you look at the members of the Commission, I see Honorable Justice Chairman Suleiman Jaulo, they're saying QC. I think that's a high judicial status in their own domain. I'm not trying to be ideological. The Pan-Africanists, etc. Well, that's another domain. Come and reach us in our own domain. But here in this domain, it shows capacity to think and situate your knowledge. And that knowledge is being situated to build a constitution of our republic. That's what they're capable of doing at this moment. You look at Honorable Hawa Kurusi Sabali, who was the Attorney General and Minister of Justice in 1997. Institutional memory of the 1997 Constitution. You have Abidjouf Cole, a journalist of profound, and a woman of profound integrity. Dr. Melvin George, you can see just the doctor is enough. Dentist of profound integrity. Fatoumata Jallow, former Auditor General. You see Gay Sow, consultant, legal consultant everywhere. I've met him in so many domains in West Africa, where he is held in high repute. When we look at all this ECOWAS, etc., is a regular consultant. You're talking about national asset. Janet Ramatulai Salajai, who does not know her? These are people who have performed all functions, judicial functions in this country. Who does not know Lamin Kamara? If you have these cases, just go and have a criminal case. You say, who do you think first? So essentially, we are talking about Salimata E.T. Toure, Yankuba Diba, Yankuba Manjang. You're talking about people who, for one reason or another, had something to contribute. And therefore, we should not look at our national assets and try, by all means, to trivialize their efforts and their actions. You can only interrogate what they have done by going and write and show us where their flaws are and how they have plagiarized anybody. But essentially, constitutions, honorable, in terms of principles, in West Africa and Africa, they are talking about constitutional convergence. So the more we converge our constitutions, the more we move towards African integration. So the Gambian constitution ultimately could be a constitution that others will take. That's what we want. That we have added value to it so that others will come and take it and utilize it. This is not a nationalist agenda. It's agenda of building. We are building a better constitution than some of these countries. Do you have time limit in the United States? That is like the time limit that we are talking about. And what I mean by that, do you have second round of voting? Maybe that was not the right question to ask. I'm talking about the 50% majority. Do you have that in the United States? You don't. It's forced past the post. But we are building up an architecture of real democracy. We are talking about 50% majority before you become a president, even if you lead. So these structures will ultimately be emulated in other parts of the world. So in conclusion, Honorable Speaker, I would request ultimately that the mover reviews what has been said, and if we see in certain areas, then what may end up being the best mechanism, because if you look at it, Honorable Speaker, again, that the Commission's term, yes, under clause 8, the term under clause 9, the term of the Commission was supposed to be 18 months, and then it can add another 6 months, and that's why they carried out their work and provided us with what they could provide. Now, we have seen under clause 22, the Commission shall stand dissolved within 1 calendar month after the date of enactment by the National Assembly of the bill introducing the Constitution. Of course, we know that that is not entirely the procedure that ultimately will have to happen. So in that sense, the Commission exists now for the National Assembly. Could we be creative and get the Commission to be able to sit with our committee, not to look at the details of, but to see what people say. Chair, these are the things, and they give reasons why something could be added or cannot be added in terms of the context, so that we resolve this issue in keeping with what is in line with the duty we have given them. We cannot transform ourselves into a drafting committee. It is important that they continue their work, because if we touch it and it goes to the people and fail, who will hold them accountable? Maybe what you put there is why people rejected it. What they put is what they know the people will accept. Let's put it before the people, and then if we need improvement, amendments will come, and maybe some of you may become president someday, and you can introduce a fourth constitution of the Fourth Republic. So it's left to us to improve our constitutions as we go. Thank you very much.